Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be talking about the collapse of Portland's rapid response team after officers resign en masse in the wake of one of their own being charged with assault during the protests of 2020. We're going to catch up with a recent Supreme Court of the United States decision interpreting the Fourth Amendment's hot pursuit exception. And we're going to be talking about the conviction of a defendant who represented himself in a murder trial. During segment 2, as promised, we'll be exploring the recidivism factors of 292912 in the Ohio Revised Code. What are judges looking at when they decide the appropriate sentence to impose on a felony offender? And which factors guide the court in crafting those sentences? To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube. Look to the law office of brianjones.com and all of our social media outlets for everything you need to know about your civil rights and the criminal injustice system. So, Erica, did you see in the news this week that the entire Portland crowd control unit has resigned their positions after one of their own was indicted for assaulting a protester last year?
Wow. I mean, that's amazing. The whole force. Did they also step down from their jobs as police officers or just for crowd control?
The officers resigned from this special duty assignment within their regular duties as law enforcement officers. They didn't give up their jobs. I mean, they've got a point to make, but it only goes so far, right, Erica? The assignment is a volunteer position within the force, and the officers are not screened. They're not vetted for it. They just get to volunteer. Now, if there are nobody volunteering to participate in the crowd control unit, regular uniformed officers will be used to respond to protest and civil unrest situations. So it's not like there's no crowd control unit available at this time. It's just the officers that voluntarily put themselves out there to try and be these armed mini militia officers aren't going to do it anymore.
Wow. I mean, that's amazing. I mean, and especially like I read a little bit ahead here to find out the answer to this, but why don't you let the crowd know, like, what is the crowd control unit? Why is this so special?
So you may remember seeing in the news last year what appeared to be paramilitary outfits marching through the streets, beating reporters, beating members of the community, beating protesters indiscriminately, firing rubber bullets into crowds, throwing flash bombs, driving armored tanks down the middle of America's streets. That's these guys, the crowd control units that get the surplus military gear and decide to go out during protest times and play dictators' little stooges. The units are comprised of officers that have been trained to move in coordinated and strategic manners in order to try and condense and corral protesters into small and ever increasingly cramped areas, or to force them to disperse entirely. Now, these officers have been featured prominently in the Black Lives Matter movement because of their treatment of reporters, because of their treatment and beatings of little old ladies, and the traumatic brain injuries that they've given to little old men. And the media coverage has rightly focused on them as part of the protests, and often their abuse of power has been highlighted, which is an ironic response to citizens saying police are being too brutal and using too much force for them to come out and use more force and be brutal.
Wow. I mean, that's amazing, since you said that they don't really do checks on them to see if they're mentally stable enough to do this. They don't really have the right training for it. I mean, that sounds like just a recipe for disaster. So what is your reaction to this development in police accountability?
Well, I think it's disappointing and it's disheartening to see officers resign en masse rather than support accountability for this abuse of power. The pandemic and the prolonged protests in Portland and across our country have left this and a variety of police departments demoralized and feeling like they don't have any political support. But when the party line message, when the thin blue line message is don't throw out the bushel because of a couple of bad apples, it seems ironic that the entire bushel would then go and support the bad apples. This is why my number one request for police reform is accountability through whistleblower requirements. Corey Budworth, who's the officer that was indicted in this case, was seen beating a reporter over the head with his baton. This is essentially smashing somebody's head in with a baseball bat. His colleagues saw him do it, and now that he's being held accountable, the rest of the unit is choosing a take my ball and go home to pout mentality rather than supporting the criminal justice system that they believe is good enough for the rest of us. If it truly is a single bad apple in the bunch, they should single that apple out, ostracize it, and make it submit to the appropriate consequences for behaving in that way. While this mass resignation may be interpreted as some kind of sign of unity and support, it is no more than a stark reminder that the thin blue line that prevents officers from holding each other accountable and protecting the public from rogue members of their ranks is more important than their oaths to uphold the law.
I mean, I couldn't agree with you more. That sounds horrible, and I am I'm really disappointed in them as well. And I understand, having a brotherhood and there are fraternities and everything in college and clubs everywhere. But like you said, when your whole job is upholding justice and you can't support somebody getting punished for doing something wrong because they happen to be on the police force, that's just unbelievable. And I think that they should feel shame for what they've done.
Absolutely. And not only this particular officer, but any officer that supports him and resigned this position in support of him. The reality is that these are the same officers who day in and day out sit around in courtrooms across the city of Portland and really across the nation and lament that the criminal justice system takes too long, and why don't these dirtbag defendants just plead guilty so we can move things along? Well, now we've got one of their own accused. And isn't it funny how their mentality changes and how they don't want to single out the bad apple? I think it just demonstrates, Erica, that the reality is that there aren't a few bad apples. The problem is the majority of the apples in the basket are rotten, and there needs to be systemic change to remove them from the basket so that we can get the good apples in and have a legitimate policing force in the United States. One of the ways that we make these systemic changes is through case law. And Erica, did you see the Supreme Court issued new rules for searches and seizures under the Fourth Amendment this week?
I did. I find this incredibly interesting, and I feel like it's going to make a lot of positive changes, and less people are going to get hurt and possibly die uh, because of the story we're about to talk about. And let's talk about this. How did the case arrive at the Supreme Court?
Arthur Lang was a California resident who was driving home one night, listening to his loud music and honking his horn to the music. It drew the attention of a police officer who followed him home, and 4 seconds before he drove into his garage, the California Highway Patrol officer activated his overhead lights. Mr. Lang, as any normal person would do, put his garage door down after he parked his car in it, but the officer stuck his foot under the garage door, preventing it from closing. Ultimately, he put Mr. Lang through field sobriety tests and arrested him, accusing him of OVI and a variety of other charges. Mr. Lang challenged the tests, the search, and his seizure, the officers sticking his foot under the door, through the Fourth Amendment to the United States Constitution, and he lost at every level until he got to the Supreme Court, who ruled in Mr. Lang's favor and threw out all of the evidence.
Wow. I'm speechless. I mean, I can't even imagine that happening. And also, I wish that I was having as much fun listening to music in my car. It sucks that he ended up getting arrested. But yeah, let's talk about, what the Supreme Court decided.
I mean, who among us hasn't just really gotten into the music and started driving to the music rather than, maybe the conservative and defensive way that we were taught in driver's school. The Supreme Court understands that desire to really get into the beat because they've raised the bar for the exception to the warrant requirement that the Fourth Amendment imposes on police. So remember, let's start from the beginning. The Fourth Amendment requires the government to leave you alone unless there's a warrant or probable cause. So that warrant has to be supported by probable cause. So really, probable cause is the standard. Is there a reasonable belief that an average person would believe that a crime has been committed and that there's evidence of that crime in a particular location or a particular person is that criminal? Now, typically we want a neutral and detached person, a magistrate, a judge, to make that decision. So that's the reason that we have the Fourth Amendment's warrant requirement. Police officers have to go ask permission before they can drag you off to jail or before they can rifle through your things. But the Supreme Court has consistently created exceptions to that rule for a variety of reasons. And in this case, we're talking about the hot pursuit exception. So if there is an ongoing crime and the police are in the middle of the chase, in hot pursuit, the police can continue their pursuit even if you get into your house. There's no magic I've reached home base exception. The police can come in and arrest you. But what the Supreme Court has unanimously decided in this case is that police really have less leeway when they're investigating misdemeanor crimes, less serious crimes, as opposed to felonies and violent offenses. Justice Elena Kagan noted that the flight of a suspected misdemeanant does not always justify a warrantless entry into the home. An officer must consider all of the circumstances in a pursuit to determine whether there is a law enforcement emergency. And there's two critical aspects to that statement, Erica. First is the sanctity of our homes. There is no place more protected than our homes. And second, it's really a callback to, I would say, the early 20th century jurisprudence of the Supreme Court when we talk about a true law enforcement emergency. That's where these exceptions originated from. And what the war on drugs did was it really gutted that and reduced the standard for what an emergency is. Time and time again, both circuit courts and the United States Supreme Court said, well, war on drugs, pretty important. War on terrorism, pretty important. So we're going to call an emergency something that's less than an actual emergency. And I, for one, applaud the Supreme Court for coming out and saying, no, an emergency is an emergency. And you can't violate the sanctity of my home unless there is a real emergency. The officers now have to demonstrate a good reason to enter someone's home. And that has to be an imminent harm of violence, the possibility of destruction of evidence, the possibility that the suspect will escape in some way. And when we think about the circumstances of this case, Erica, we can see how easy it would have been for the officer to get a warrant. All he had to do was stay outside the home, call for some backup, station somebody at the back door of the house. And now the suspect isn't going anywhere. They can make a phone call, write an email, send a fax, get a warrant to seize this individual. This day and age, with the advent of technology and the ease with which an officer can communicate with a neutral judge, there really is fewer and fewer reasons to violate the Fourth Amendment's warrant requirement. And I hope the Supreme Court continues down this path and recognizes law enforcement's ability to have that neutral person in the middle. Because among all of the things that we fought for during the American Revolution, as we come into July 4th, the Declaration of Independence, one of the major problems that the colonies had with the crown was that repeatedly officers of the British government were kicking in doors for no reason other than you disagreed with the king. And we don't allow that in America. So I'm really proud of the Supreme Court's decision in this case and how they reached that decision.
Those are all great points. And I think that you stated it beautifully. There's a reason that changes were made. There's a reason that we had a revolution, and there are no kings. There's, a whole democracy. And, unfortunately, it gets challenged, and things need to be changed occasionally with the changing of times. And that's what we're doing. And this is, I think, amazing as well. So can you tell us, how is this ruling significant to the defense community? And like, how are you going to be able to use this in your upcoming cases?
I think there's a couple of ways. So the Supreme Court has recognized the distinction between misdemeanor and felony crimes. And it's reinforced the idea that the lower level offenses are not the world-ending emergencies that law enforcement would like courts to believe. And the courts really, like state level courts, municipal courts, the courts that deal with, the average everyday criminal activity that goes out there, criminal allegations that go on out there, have to take into consideration the practicalities of what they're deciding. The violation of the home for a theft charge is significantly more harmful from a citizen rights point of view than that same violation to investigate or catch a murderer, somebody that's assaulted somebody, an armed robber. These are situations which the warrant requirement becomes less critical because the emergency of the situation is so much higher. Now, on the other hand, and practically speaking, the factual bar for establishing an exigent circumstance is incredibly low. So we'll see how in practical application this is used. But I think it really gives the defense bar the opportunity to make this distinction between very serious, dangerous offenses and less serious, less dangerous offenses for the community.
I think that's great. And honestly, it's like just helping the police officers just stop and think about the severity of the situation before they take action and decide which actions are actually necessary. They're going to be thinking about how it looks in court later when they overreact and kill somebody for carrying in some subs to a birthday party. I mean, I know I bring that up. That is just still like one of the most shocking things. I mean, can you imagine if they knew, and there were already a bunch of cases where this had been shot down, they weren't able to just go into somebody's home without a really good reason.
Absolutely. And I think you're right. Hopefully it sends a message. Hopefully the police receive that message that, and again, this is something that we've talked about a variety of times. It is not, the police are not an occupying force in citizens' communities. And police have to stop looking at the average citizen, the average non-police citizen, as an enemy combatant in a war zone. They've got to come together. Policing has to get back to what it used to be: protection and service, instead of investigation, inquiry, prosecution, and conviction. That mentality has to switch back, or else the protests are going to continue. They're going to get worse. And we're going to have more and more people getting shot for carrying foot-long subs.
It's pathetic. And it's scary, and it makes me feel like I should be, careful if I've got an umbrella or, handful of something that may look like a rifle to them. I just, you got to be careful. So, and if you're a person of color, it can be worse, and you're more likely to be judged quickly.
Yeah,
I mean,
absolutely.
that's what we talk about all the time.
Yeah. And that's exactly it, Erica, is that, not only is this a problem for every citizen in America, but it's particularly a problem for people of color. Lastly, Erica, in this week in crazy court news, did you see that Ron Oneal represented himself in a double murder jury trial and was convicted?
I mean, that is amazing. I did see that, and I was kind of comparing it to this show that is on Netflix right now. Have you seen it, Betty Broderick? It's like the Dirty John series, and she committed a double murder against her ex-husband and new wife and represented herself. It didn't go well either. I mean, so that's actually based on a true story as well. But I mean, you watch that stuff on TV and you think, how can anyone in real life think that they can represent themselves in a double murder? And I mean, is it even possible for someone who is not a lawyer to represent themselves in a capital murder trial?
This is the structure of a question that I get from a lot of clients, Erica. Is this possible? Is that possible? Can they do this? Can they do that? And in the law, frequently the answer to that question is, well, yeah, they can do it. Whether they should, or whether it's appropriate, or whether it would get overturned on appeal is a completely different question, and the one that you actually want the answer to. So in this situation, can a person represent themselves? Yes. The accused has an absolute right under the Sixth Amendment to the United States Constitution to represent themselves. And the fact that this is a death penalty case has absolutely no bearing on Mr. Oneal's right to represent himself. In a lot of jurisdictions, the court will require an attorney to sit second chair and be on standby to assist the defendant if necessary. But judges can also make that second chair attorney a potted plant where they're not allowed to assist or help until the defendant specifically asks and gives up the right to represent themselves. And the judge has the power to revoke that right at trial if the defendant abuses his position in the courtroom. So if a person is representing themselves and they're not behaving according to the standards that the judge would hold an attorney to, the judge can revoke that right. Now, what happens in that situation? I think we've got a lot of problems in a variety of areas. But long and the short of it is, to answer your question directly, Erica, yeah, people are allowed to represent themselves in court. One of the, there's a reason that there's the trope, the man who represents himself as a fool for a client.
Yeah, and I just heard that the lawyer that represents themselves is also a fool. You don't want to, even if you were an attorney and you were in trouble for a double murder, you would have an attorney, because it's just crazy to try to represent yourself when you're going through something like that. So, I mean, in either direction, I think you should always have an attorney to help you through a court case, especially something so important as this. So can it like, okay, I mean, I know there's plenty of attorneys that support themselves. That's not what we're talking about. But if you're not an attorney and you want to represent yourself, are you allowed to do everything that a trial lawyer would do in a courtroom?
So not only is the accused allowed to do everything that a trial attorney would, the accused is required to, expected to. They're held to the same standard of a licensed and trained attorney. Now, some courts may show some latitude to pro se defendants, people that represent themselves. And the rules guiding everything from evidence to procedure still apply. And some judges will allow a little bit of leeway in that, but they're not required to. And in fact, the standard is the pro se litigant is required to be held to the same standard as a licensed attorney. Now, there's a reason why lawyers are required to complete a bachelor's degree and then secure a doctorate of jurisprudence. There's an incredible amount of complexity that goes into understanding all of the rules, the arguments, the procedural requirements, not to mention the high level aspects of storytelling and narrative that go into trying a case to a jury. I liken this situation to those chess grandmasters who play dozens of games of chess simultaneously. Except in trial, we're playing chess and checkers and Monopoly and Settlers of Catan and Risk. And we're doing it all simultaneously against a variety of opponents.
I absolutely agree with you. And I will never try to represent myself in a court. In fact, if I ever get in any kind of trouble criminally, I hope that it happens in Ohio so that you can represent me, because you are the best and you keep up with all of this stuff and you'll know the best strategies. So I got to ask you, um, if you're stupid enough to represent yourself, are you then allowed to go back and appeal a conviction on the basis of an ineffective assistance of counsel?
Well, so two things, Erica. One, you don't have to get in trouble in Ohio to hire my services. I can practice across the United States. There's a couple of procedural bars that I would have to get across, but for the most part, we can get through that. So
Phew. All
when we
right.
inevitably get in trouble, I'll be there for you.
I'm going to have a crazy weekend now that I know that. Thank you.
I got you, Erica. But to answer your question, no. You cannot claim you yourself were ineffective as counsel. And the Supreme Court decided that back in 1975. The defendant who represents him or herself cannot later appeal that conviction on the basis of ineffective assistance of counsel. And the reason why a decision to proceed pro se is so heavily scrutinized, it's absolutely, there's a whole series of questions that judges go through when somebody says they want to represent them pro se. It's a big to do, and it's frequently revisited throughout the course of litigation and even throughout the course of the trial. At voir dire, after opening statements, after the questioning of witnesses. The judge will keep asking, in many situations, a judge will keep asking a pro se litigant, are you sure you want to do this? Do you want the attorney to step in? Do you want the attorney to step in? And because the mistakes can't be corrected later. It is one positive thing that Mr. Oneil has now accepted the help of attorneys during his sentencing phase, because this is a death penalty case. So he's been convicted of the crime. Question now is, will the jury give him a death sentence? And he has accepted attorneys at this point. One of the things that I wonder now is, will the Supreme Court revisit the Ferretta decision, Ferretta versus California back in 1975, that said a pro se litigant can't appeal their own ineffectiveness? Because this current makeup of the court seems to have very little regard for precedent. So they seem to not really care what prior Supreme Courts have done. So will this issue come back and be redecided by the Supreme Court.
Yeah, I mean, it is going to be very interesting to see what happens because, like you said, there's a lot of changes. You can't just always assume that they're going to follow precedent. And I hope that you'll be able to update us on this later on.
We absolutely will. We're going to keep following this case. We're going to see if Mr. Oneil gets the death sentence, and we'll follow it through the appellate process. Now, Erica, last week we looked at the first half of Ohio's sentencing factors under Revised Code Chapter 2929. We looked at the seriousness factors. Today, we're going to take a closer look at the other half of the factors that guide judges in determining what an appropriate sentence is for a convicted defendant, and that is the recidivism factors. So let's get into this second phase of the sentencing decision-making process, which is the recidivism factors.
Say that 10 times fast. Not that, recidivism. Oh my gosh. So can you tell us what the recidivism factors are?
Yes. So there are 5 considerations that a judge looks at to determine whether a particular defendant is more likely than other defendants to commit crimes in the future. So recidivism is the likelihood that a defendant, recidivism is the commission of subsequent criminal acts after being caught for a criminal act. So recidivists are people that have been convicted and then commit new crimes. The recidivism factors are designed to give the judge an objective metric to decide if this individual is more likely than other people to commit crimes in the future. And the 5 factors that the judge looks at to say, yes, this person is more likely to commit future crimes is if the crime was committed while the defendant was under supervision, whether the defendant has a history of criminal convictions or juvenile adjudications for criminal conduct, whether the defendant has a history of unsuccessfully completing probationary sanctions. And these 3 are really kind of facts beyond change. It's not, they're set in stone at the time of sentencing. The last 2 are whether there's a demonstrated pattern of drug or alcohol abuse that's related to the offense. And it particularly looking at whether the defendant refuses to admit to that abuse or refuses treatment. And the last is whether an offender shows no genuine remorse for committing a particular offense, which is a wholly subjective determination. We look at these factors, and the arguments that can be made really lie in those last 2. But I would say this with regards to the first 3. It's almost like triple counting for the same thing, right? Because if you're currently on probation, then you've got a history of unsuccessfully completing probation, and you've got a history of criminal convictions. So in this regard, I think these factors are really unfair to the criminally accused because it's triple counting the same conduct. But it is what it is. That's the second 2 factors, or I'm sorry, the last 2 factors, the pattern of drug and alcohol abuse and the showing of genuine remorse are the places where we work very closely with our clients, and our concept of holistic criminal defense really comes into play. We make sure that we get preemptive assessments. We get people into treatment. We get them addressing whatever it was that brought them into the criminal injustice system. And while the statute specifically says drug or alcohol abuse, time and time again, I go into court and I argue that mental health issues should be considered under this prong as well. And that is a due process equal protection violation to not consider mental health illness as a factor reducing the likelihood of future crime. And then, of course, explaining to our clients and getting them to understand that remorse is not just about being sorry that you got caught, but more importantly, being sorry for the consequences, the negative implications that their actions put on their victims, and getting them to understand that, embrace that, and then express remorse for the harm that they have caused to those around them, not the harm that they are experiencing because they are facing the possibility of going to prison.
That is unbelievable that they don't consider somebody's mental health. I mean, we've seen so many of these crimes have a lot to do with someone's mental health.
I think it's I think it's particularly ironic that this part of the sentencing statute hasn't been rewritten in light of a variety of other portions of the Ohio Criminal Code that have been rewritten to include mental health. So I think this is one particular area that the legislature has overlooked, and we have been petitioning the General Assembly to fix this problem.
So, do they prioritize these? Is one factor more important than the others?
Under the law, no. According to the case law, none of the factors should be given any more weight than any of the others. In practical application, absolutely. And this is what argument is all about. No one factor should be more or less important than the other factors. But what we see time and time again is, especially that genuine remorse factor, is given significant weight by judges. And even more so when the judge determines that there is no genuine remorse. If a judge determines there's no remorse for the criminal act, the likelihood of a prison sentence or a more harsh consequence is drastically increased. So while objectively there should not be any factor that's more important, what we see time and time again is that that particular factor is elevated above almost all of the other sentencing factors.
Wow, that's amazing. So now when they're looking at these, are there any factors that make it so that the defendant is less likely to commit another crime?
Yes, exactly like there were more serious and less serious factors when we talked last week about the seriousness factors, there are 6 considerations that a court must make when determining whether somebody is less likely to commit future crime, recidivate. The first is whether the defendant has any prior convictions. So it's the flip side of the coin of those first 3 considerations for the more likely factors. Is there a history of juvenile adjudication? Is there a history of criminal convictions as an adult? Even if there was a history of criminal convictions, the third factor is, has there been a significant period of time wherein the defendant lived a law-abiding life, a significant gap between convictions? Although, in my experience, Erica, that knife cuts both ways. You should have learned your lesson so long ago. And I often see judges almost holding this recidivism factor against the defendant. The last 3 are whether the offense occurred under circumstances that aren't likely to happen again. And this is a critical factual argument that can be supported by expert testimony and assessments. Again, this is an area where we make those mental health and drug dependency arguments. Genuine remorse is a factor. If the offender shows genuine remorse, then they are less likely to commit future crime. And again, this is totally a subjective determination by the judge, but one factor that can be really controlled by the accused, and why we take that approach so that our clients are in a good mental and emotional place to be in tune with the remorse that needs to be shown in the courtroom and through the pre-sentencing investigation process. And last but not least, whether the offender has served in the military. If they are a veteran, they have a variety of additional programming consideration options that are available to the judge and that we can explore throughout the litigation process to, again, take that holistic approach and get people the treatment and help that they need to reduce these recidivism factors. Because what the primary approach that we take is we can really control a lot of this recidivism consideration through our holistic approach. The seriousness factors, that happened, that's in the past. We can argue about how serious this crime is, but that's all we can do. We can't control what happened. but we can influence whether the defendant is viewed as somebody who's likely to do this again. Does the judge have to protect the public from you? And we take that aspect of the sentencing consideration very seriously. We are very aggressive about it. And honestly, I'm disappointed in how little most defense attorneys put into this aspect of the criminal defense process.
I mean, it's really just proof that the law is just such an intricate uh, job to fulfill. And I was just saying this as I was talking to you before we started. Your job is very interesting and very difficult, I think, because there are so many strategies. And if you forget about something, it could really affect somebody's whole life and their family's life. And, they could lose everything. And what is there besides the right to live free? That's why we're here.
Absolutely. Yeah. Freedom is there's nothing more valuable than being free, being out of incarceration.
So, can you, just to wrap this up, in talking about strategy, what is the most effective strategy in addressing recidivism factors?
Yeah, so I think there's three prongs to this. First is an expert assessment. We want to get a sex offender risk assessment. We want to get an alcohol and drug assessment, anger management, sexual interest testing. Whatever it was that we discover was the thing, the problem, the illness that triggered the antisocial behavior. We want to get it assessed. We want to get a treatment plan for it. We want to get experts involved in addressing it. Second, we want to work with our clients one-on-one and to develop them as a person through personal growth and developing empathy for their victims so that we can present that at the sentencing hearing, so that they can present that at the sentencing hearing, so that they don't just come off as remorseful, that they demonstrate that they are in fact remorseful. And last but not least, writing a sentencing memorandum, submitting a written argument supported both by the facts and the law in support of a successful, a reasonable and appropriate series and set of consequences for the particular crime committed by the particular person.
I guess truer words have never been said. So I appreciate you giving us all of this information and education on how this works, so that, if we ourselves or one of our family members or friends or colleagues gets into trouble, you realize that there are ways to really make sure that you have the best outcome for you and your family.
Absolutely, Erica. And thank you for engaging me in this discussion today. And everybody out there who heard our podcast today, thank you for listening to us. To become informed about the latest legal decisions that are affecting your rights, police and government accountability, sentencing considerations, and everything you need to know about your civil rights in the criminal injustice system, look to the law office of brianjones.com. Find us on Facebook at facebook.com/Central Ohio Criminal Defense, and at TLOBJ on Twitter, Instagram, and TikTok. We'll be back next week with a sui generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of the origin of the exceptions to the Fourth Amendment warrant requirement in the United States Constitution. Now, Erica, my grandfather always told me, don't do anything I wouldn't do. And to that, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.